Full Melt Show is intended for a mature audience. It contains adult themes, adult content, and sometimes adult language. Listener discretion is advised.
It's the Full Melt Show.
And we're on the air.
Are you high? What are you talking about?
It's the Full Melt.
The Full Melt Show. A marijuana discussion about news, culture, politics, and lifestyle. FullMelt.com. Toll free. 844-420-TALK. 844-420-TALK.
Hey there, hi there, ho there. We are back. It is Monday. Today's what, the 25th, 26th? It's in the mid-20s in January already. For crying out loud, January 25th comes very quickly. I'm Steve Green. This is the Full Melt Show. It's freezing outside here. Wasn't actually too bad today. I can imagine it's only colder and snowier in the northern parts of our state, where many of my friends and comrades, compatriots, however you want to call them, supporters, activists, I suppose. I don't like that term, activist. I mean, I guess it is descriptive, but it's kind of been like labeled now. It's when you say activist, you get, pictures of, Greenpeace and PETA in your head. And I'm not saying anything about any of these other organizations. I'm not going to walk down that road. I'm just saying it's got a label on it now that isn't necessarily applicable. It's really easy to label people as activists and call them kind of, a little bit nutso in your own head. Just as a citizen, I'm just saying, if this issue, hold with me, stay with me now. If you're just a regular old citizen and your initiative wasn't marijuana, your passion, the thing that you're bringing to the legislature's attention because nobody's doing it isn't cannabis, but say is corn or anything agricultural for that matter, or just anything other than cannabis. Let's say it was the wolves issue or, a hunting related issue. Do you think that you would have the same view of the term activist? Like if somebody said that there was a hunter activist today that was on trial for his guns. I mean, I realize that's a silly. I realize that is a bit of a silly way of putting it, but it does draw the point back around, which is if this wasn't a cannabis issue and you said the word activist, you get this label that pops in your head. You know what I mean? It's a wacko label. It's a crazy label. It's, those people are really out there to be out there doing that. Either their cause has to be really good, which I believe our case is, or, and who doesn't if you're a part of one of these groups, or they're just kind of out there on the edge. Are you going a little bit hard and heavy at that, aren't you? I mean, maybe this isn't such a big deal. And I suppose that there are many people inside of Michigan's borders that hear this news that are much like that. Oh, these crazy pot people. And that's why I don't like that term activist, because the moment that you say it, all those, terms pop into people's heads. You've begged the question. Now it's just looming there until it's answered. I'd rather not beg the question with the term activist because, like I said, although it's an accurate depiction, it does bring about this generality, this stereotype that I don't like. And so this brings me to our subject up there in Gaylord, which is the big 800-pound gorilla in the room right now, isn't it? It's the subject of Allen Witt, who I believe, even though I'm going to use the term, see, now I've already said the term, so it doesn't matter anymore. The effect is negated by previous saying of the word activist. But I suppose many would consider Allen Witt an activist up there in Gaylord. And some would just consider him, I don't know. I think from the standpoint of brevity, that's not the word I'm looking for. See, Allen's much like I am in this respect. I'm willing to take my morals to the grave with me. So in other words, if I said I'm innocent, I'm innocent. And if I believe I can prove that I'm innocent in court or that I shouldn't be tried or that I have an excuse because I have permission under the law, which is what that whole Section 8 defense thing's up there in Gaylord, I shouldn't be convicted. There are a lot of people paying attention to Allen because most people don't get to the stage in the game he's at. You know why? Because they plead out. And I'm not saying that that's a good or a bad thing. I'm not an attorney. I can't advise people to go against their attorney's advice. And many of these people do this in the face of their attorney saying, look, if you don't do this, you've got multiple felonies they're going to probably convict you of. And given that we can't say that you are, the judge said you don't get a Section 8 trial. You can't tell the jury you're a pot patient. So you're just going to go down as a drug dealer now. And I'd love to defend you against that. We've got a good shot, but it's my job as an attorney to tell you that, the risk is high. And it's going to be costly. It's going to cost you money to challenge that risk. I'm an attorney. You're going to have to pay me to go to trial, which is much more expensive than settling out. Because I can't tell you how much it's going to be. It depends on how long it gets drug out. But I'm going to tell you I'm going to need a substantial amount to defend you this way. And chances are you're going to go down as guilty anyways. It's my advice to you as an attorney, and I'm just saying this. I'm not an attorney. I'm just posing a situation here. To plead out. Let's offer them a plea, or let's see if they offer us a plea. Usually I don't know. It's a good question for our guest. I was going to say, is it generally the practice that you wait for the prosecution to offer you a plea deal? Or do you go to the prosecutor with a proposed plea deal behind closed doors and beg the question that way? Or do you bring it formally? I want to know about that process. I've never had to step through those rings before. There's a lot of stuff in court I've had to step through. That's not one of them. And even assuming that I had, my experience through that isn't necessarily representative of anybody else's experience in the same situation. And so there are a lot of people that look to Allen Witt as, I suppose, a champion, a hero, because he's got the intestinal fortitude to stand up on the principles of his morals and him trying to say, look, I'm a citizen here. I am not a criminal. I'm doing what I'm doing by necessity and according to the law. I mean, that's ultimately what he's saying here. And today, so let me give you the background of this for the people. I guess there's a lot of people here in the state that understand this story. Maybe some of them don't. There was a set of raids that occurred recently up in Gaylord, Michigan, which is, it's a stone's throw from the Mackinac Bridge. It's like the last major city before you get to the Mackinac Bridge. And when I say major city in northern Michigan, it's still a pretty small town. I used to live in Gaylord, by the way, right at the main 4 there. At Main Street, and what is that, M36? What is that? The M54? What goes through there? I can't remember the name of that route. M52? Might be 52. Memory serves it's 52. I can't remember. It's been since I was 21 years old that I lived at that location. It was definitely in the middle 80s. And the town has grown since then. But I am familiar with the area in Michigan we're talking about. It used to be at least very desolate in the wintertime, except for the people that were coming up for like Houghton Lake Tip-Up Town, that kind of thing, partying on the lake. That's still significantly south of Gaylord. But you'd get some residual traffic up there snowmobiling and having fun. And, there's a lot of, I suppose, recreational activity available for outdooring in the Gaylord area. So there are a lot of people come up there for that. It's pretty scenic. It's beautiful up there. But when you get to these small towns, they're very conservative. And Gaylord is one of these places where the marijuana crowd has pushed back and said, we want to establish some permission for dispensaries. And I think there's a whole process up there in Gaylord that occurred. And I am not extremely familiar with it, although I do have a general grasp of it. I will let our guest do the explaining because he's more equipped to. He's more knowledgeable in this place. And I'm going to invite you in on that conversation at some point. If you'd like to write the number down, you can. It's 844-420-TALK. I'm hoping you're listening to the program live, and you'll be able to ask Mr. Covert some questions or give an opinion or express a concern. That's what we're here for. I mean, that's what this whole rigmarole is here for, this as far as this radio show goes. Joshua Covert is a Michigan attorney, and in my opinion, a damn good one at that. He hails from the East Lansing, Michigan area of the Nichols Law Firm and has handled many of these cases in the past and has some notoriety behind him on that issue. I do not have a formal bio for Mr. Covert, and I'm hoping that you will have the opportunity to perhaps take a sneak peek into Michigan courts and why we here in Michigan are trying to do things like legalize or abrogate. These are individual petition drives set to change the tone with police and prosecutors regarding the possession, use, sale, manufacture, distribution of cannabis in the state of Michigan. And this has been a long argument, a long-going argument for quite some time, since even before. In fact, I would argue even decades. I would argue going back to the early 70s. This has been an issue for Michiganders in Michigan going their route to oppose federal and local law regarding the use of cannabis by adults in this state. In 2008, Michigan passed the Michigan Medical Marijuana Act by people's referendum, by a citizens' initiative, a petition drive. And since then, the chief person opposing that drive, he was the only one advertising against it, Bill Schuette, we hired as our attorney general in that same year, in that same election process. Some of what you'll hear next is the result of those events that long ago. And they're coming up next here on The Full Melt Show.
You're getting The Full Melt.
When you need legal help, you don't want to guess at who's standing next to you in court. And when it comes to a medical marijuana defense, it's even smarter to partner with a lawyer before you need one. Based in Royal Oak, David Rudoy has a proven history of not being afraid to take your case all the way to the Supreme Court and win. Find the law offices of Rudoy Law
at RudoyLaw.com.
RudoyLaw.com is a quick reference on your rights concerning Michigan medical marijuana
and up-to-date news.
That's RUDOI Law.com. Call 248-935-9074 now and talk about your legal needs, because at RudoyLaw.com, we don't just stand up for you, we stand up with you.
RootMetrics, in the nation's largest independent study, tested wireless performance across the country. Verizon won big with 153 state wins. AT&T got 38, Sprint got 2, and T-Mobile got 0. Verizon also won first in the U.S. for data, call, speed, and reliability. AT&T got text. Stuck on an average network? Join Verizon, and we'll cover your cost to switch.
It's Steve Green for the Sweet Leaf in Flint, because now getting safe access to medical cannabis patients in Flint, Michigan is never more welcoming. Presenting the Sweet Leaf, a brand new patient experience bringing 12 carefully selected caregivers housed in 9 separate offices to distinctly assist you with their knowledge and reputation for excellent patient care. Classes and training coming soon in the large community room. Check it out in person, 400 South Door Highway, or call 810-259-2571. The Sweet Leaf Center in Flint, 810-259-2571.
What's up with these things, Victor?
We decided to give ourselves stickers for each feature we release.
We read about 10,000 suggestions a week to create features that, as traders, we'd want to use.
10,000 suggestions? Who reads all of those?
He does.
For all the confidence you need, TD Ameritrade. You got this.
Got something to hide? Canalock offers discreet and effective storage solutions that destroy odor, so nobody knows. Canalock is a patented charcoal-activated bag that discreetly stores your marijuana. Canalock is made from the same material as military chemical warfare suits. Get yours at canalock.com. Visit canalock.com to learn more about no-smell technology.
Introducing Sacred Elements, a place for natural and alternative healing for the mind, body, and soul. Sacred Elements. It's one place, all solutions.
Registered, licensed, certified, ordained.
Sacred Elements.
Massage, hypnosis, Reiki.
Sacred Elements.
Raindrop, aroma and color therapy, body detox, ministry, life coaching, weight and nutrition counseling.
Sacred Elements. Next to the Sweet Leaf, 400 South Dordt Highway, Flint.
11 to 7 daily, closed Sunday.
Call 810-259-2570. It's the Full Melt Radio Show.
Radio show.
I see a mountain in my gaze. I see it more and more each day. And what I give takes away.
So we're back, but I am missing our guest. It seems that Mr. Covert may be caught off guard by my phone call. I am calling from a different number in the studio than I've been talking to him earlier today. I got to see if he's there, though. And so this is part of what happens in live radio. I do not have a show producer in here today, so I am managing this myself as we speak on the air. It's 7:23. You can hear the Full Melt Show Monday through Friday from 7 until 8 p.m. Eastern Time at thefullmelt.com, and then also on Spreaker. The Spreaker website has a place where you can click through to our show. Just search for The Full Melt. You can also get us on iTunes. If you want to go to thefullmelt.com, find the link there at the top of the page and click on that. You can subscribe, just that simple, to us via iTunes. Additionally, recently releasing a couple of mobile apps for both Android and iOS. Developing yet a third with much more functionality. And we're in the process of doing that right now. But you can subscribe to, or not subscribe, but download either one of those apps. The links, I believe, are available at thefullmelt.com. In either event, if they're not, if you don't see the links there, you can go to the App Store or the Google Play Store and just search for The Full Melt Show. And use those 4 words, The Full Melt Show, and you'll find us very easily. You'll see the Full Melt logo. You can hear the show there every day, both live, and you'll find a list of all of our former shows listed below. So I'm still trying to raise Josh Covert. He's our guest here today on the program, assuming that I can. There we go. Here he is. I'm going to see if I can plug him in via the iPhone. Say, Josh, are you there? Can you hear me via the phone?
Yeah, I'm here. Thank you.
So I managed to put this phone on the air instead of our guest line.
Okay.
You should be able to hear callers if we get them. I don't know. If we have to, we'll call you back on the other line. I'm sorry. I know that it's been a very busy day for you, so I'm glad you've taken. I'm happy to have the time to
thanks for having me.
Take away to do the program. So, you want to give the background, the setting here for people a little bit, so that because I can fumble around with it, but you're much more close to what's going on there. Can you give people a backdrop of how this case arose, where it came from, the kind of the setting?
Yeah, in March of last year, the Straight Air Narcotics Enforcement Team executed 8 separate raids related to dispensaries in Otsego County. And one of my clients, Allen Witt, has been charged as a result of those raids and is now going to trial here tomorrow morning. So I guess that's kind of the background of how it all started. We've been fighting this in court, ever since charges were authorized, and tomorrow's the day.
Do people have been mentioning this? I think we're not real close to the case. We're trying to get a grasp of it. Does this involve in any way dispensaries?
Yes. All of the 8 raids involved dispensaries. Essentially, what happened was there was a confidential informant that went into each of the 8 dispensaries and purchased marijuana with a valid card. And the prosecuting attorney is viewing that as a violation of the Medical Marijuana Act, even though the confidential informant had a valid card.
And so has it been the contention, I suppose, from a defense standpoint, that even absent a direct connection through the registry between said confidential cardholder and the person that was acting in the place of a caregiver, had a right to do this under the Michigan Medical Marijuana Act, given the Section 8 positioning?
Yeah, that's essentially what we had asserted today was a Section 8 defense. And Section 8 defense does not require any connection between a patient and caregiver in regards to a registry. We asserted a Section 8 defense on Section 8B, which essentially says a person may assert medical use as a defense if they can assert the elements in Section 8A, which are you break it down to three parts, essentially, that there was a bona fide patient-physician relationship, two, that there was no more medicine than reasonably necessary to prevent an uninterrupted supply, and three, that it was in fact for medical use. So that was what we asserted today at an evidentiary hearing, and we put the confidential informant on the stand. This was the first exposure we had to the confidential informant. He was, I guess, just say confidential until today when we put him on the stand. So we were somewhat limited in regards to the type of testimony we received, and unfortunately, the judge didn't view that we met all of our elements in regards to that defense.
Did he explain which elements were met and which were not, or he just ruled against it?
He did. He ruled that we had the first element, the bona fide patient-physician relationship. We showed some evidence.
Can I say, isn't that the hardest generally to maintain? Wouldn't you say of those three elements that one's the hardest to have the burden of proof for at the trial?
I don't know. I think that's most often attacked. I don't necessarily think that's the hardest to demonstrate.
Okay.
I guess in every case it depends on the facts, but I think quite often the amount reasonably necessary has kind of been the one that judges have been relying on more and more frequently.
Okay. So you were saying, I interrupted you. I didn't mean to. You were going on about you were trying to talk about the events that happened today, I believe.
Yeah, we did a Section 8 hearing today, which was somewhat unconventional in regards to first doing a Section 8 hearing just before trial. We were kind of put in that predicament based on the fact that this was a confidential informant and someone that, we weren't given any information in regards to his doctor, his card, or anything, essentially, even his identity. So it was kind of unique that we had to do that today, but that was kind of the cards we were dealt.
What you're saying is that there's no pretrial discovery allowed with confidential informants. You're not allowed to put them up and depose them or ask them questions as a normal part of discovery.
It not necessarily as part of a discovery, no. Now, there are opportunities to maybe uncover the confidential informant's ID, and that was something I was able to uncover in a related case. That we did actually hold a preliminary examination in that case, primarily to obtain that information.
Wow.
And so we had his name, but he was not cooperating. We had nothing more than a name, which, that makes it hard to assert a defense. So when we subpoenaed him to come to trial, which is, again, something else that's kind of unique, that you actually subpoena a confidential informant to come testify.
Well, yeah, because you would think that they
had to do.
They would be the initiator of the complaint, in essence. I mean, they're basing the entire case around this confidential informant's purchase. Yes.
Yeah, and then one of the craziest things is that I mentioned those three elements. The third one is medical use. And if a confidential informant were to just be asked the question of, was this for medical use, they could have an incentive to just say, no, this was for recreational use. That obviously can hurt our case. That's not exactly what came out today because of the limited questioning that we presented in that fashion, but that's certainly a concern when you have a confidential informant, is that, they could essentially, they make or break your case on what they want to say.
What did you say the second element was? I think maybe that was where I interrupted you.
Oh, the second element was the amount reasonably necessary.
Right.
That was the amount reasonably necessary. Now, what the judge said in our case, essentially, was that there was a limited interaction between the confidential informant and the bud tender, and the condition was not disclosed. nor was how much medicine is normally used for the patient. So the judge said, essentially, if you don't know the condition and you don't know how much they use, then you really can't show that this amount was reasonably necessary to prevent an uninterrupted supply. Now, it was only a small amount purchased, and I think everyone would say that that's certainly a reasonable amount, but I can't envision scenarios that may, because even a small amount, an unreasonable amount. I propose to people talking today, and I'm not by any means supporting this, but I can see where the judges sometimes want more than just saying this is a small amount, because maybe somebody uses medical marijuana for migraines, but only gets migraines once every 6 months. And when they do, they take 1 to 2 hits. Then that person may not need 2.5 ounces to have a reasonable amount, or even, 6 grams or so, maybe a little more than they would need. So that's kind of where the courts are coming from, and I don't really need to be long-winded about that, but it's kind of a complex issue.
Well, no, it's important. I think look, I don't mind diving into this a little bit in depth, as long as we're not talking over people's heads and kind of getting out in the weeds where they're just like, "What are you talking about?" Because some of it can be kind of confusing. But I think we're being pretty straightforward here so far. They're really applying what is essentially a pharmaceutical standard to the question of dosing. Isn't that the nuts and bolts of what that element is?
That's what they kind of seem to be searching for, and that's not something that we can usually present, because doctors don't tell you how much to use, because
there's no standard.
So many different variables, and yeah, exactly, there's no standard. And also, if judges start telling you how much to use, that starts looking like a prescription, which doctors are not able to issue for a controlled blood substance. So doctors are fearful, when the ones I talk to even suggest dosage, because they don't want to make this look like a prescription, because they could lose their license in that respect. So the judges are asking for something that the doctors don't feel comfortable doing.
Right. And this is where it gets really confusing with regards to the law. As far as I'm concerned, and I think this is still yet a gray area. If you'll pardon that expression, because I don't like that one either. But when it comes to this standard, as it relates to the actual law, just the plain language of the law itself, it doesn't require this is a doctor's certification. This is all that the doctor has to do. He's just certifying the idea that you have a condition that may be helped by marijuana. He doesn't suggest that a certain amount is going to be helpful. He doesn't suggest that a certain timing may be helpful, because, again, he's got no guidelines, and it was never the intent of the Michigan Medical Marijuana Act to ask the doctor to perform these, functions, which would be a normal standard part of his duties, because he's not allowed to do that. Is what you're saying?
Yes.
And
yeah. I think it's no different than the doctor saying, "Hey, you should eat more vegetables." The doctor's not going to necessarily tell you how many vegetables to eat or what types of vegetables to eat, but I certainly think some doctors might say, "Hey, based on your diet, you might want to try to eat more vegetables." And I don't think a judge would require a doctor to tell a person how many vegetables or what types to eat. And I see it kind of the same thing.
Well, I suppose that people would argue, though, if playing devil's advocate, that one's a dietary standard, one's a medicinal standard, and so they would have different criteria, and so you can't compare them because they're apples and oranges. But
in some ways, they're one and the same.
It does illustrate the point either way. And the bigger thing that queries me about it, the thing that I'm most troubled by, the thing that sticks in my craw, I guess is the best way to put it, is the idea that even though there's no standard in the law itself about requiring the doctor to even look at these issues with regards to amount and timing, how much is reasonable for you to need to use, the doctor never establishes this. So how is any other layperson that's in the course of their Michigan medical marijuana duties, either as a caregiver or as a patient, supposed to grasp these numbers out of thin air? Where are they supposed to produce this information from? That's what I would want to ask.
I think the courts have given us some guidance in Hartwick and Tuttle as to what we could use to present that. I think if we have a patient that is able to describe their condition, inform the patient, the caregiver of their condition, then also describe what types or forms of marijuana they use, and also talk about what works for them, what doesn't, and how much they use. And that's something a bud tender could testify to. I certainly think they would have a much easier go in asserting a Section 8 defense. And I would go out on a limb to say that I think most judges would probably grant that defense if the caregiver can testify about those things. So I think it's really key just to maybe when you first meet a customer, and if, let's say you're a bud tender, is to maybe have that conversation, asking those questions. What is your qualifying condition? How do you medicate? How often do you medicate? How the things you've been trying work for you? And I think by having that conversation and, preferably keeping records of that conversation, you could certainly be in a much better position if you were to have to assert a Section 8 defense.
Is the bud tender considered to be in possession of said cannabis that's at the dispensary at the time he's dispensing the cannabis?
The law in regards to possession is defined quite broadly. Possession really refers to dominion or control. So basically, if you have dominion or control over the item, you would be in possession of it, and that multiple people can possess the same thing. So most courts would attribute the amounts to an individual bud tender.
And this is many times what people are being charged. So you, as a bud tender, you may not be a carded caregiver, right?
Mm-hmm.
But you might have a Michigan medical marijuana card, or you wouldn't want to be in the building. I mean, it just I wouldn't say that's a requirement, but it does pose the broader question. The bud tenders kind of need to be what's the word I'm looking for? Need to be cognizant of the idea that they may be placed in this position at some point, and that perhaps it should be a part of their repertoire to discuss these issues before they dispense any cannabis to anybody.
Yeah, I would agree.
Mr. Covert, I never had a chance to ask you how much time you have, and I know that you're busy up there. Do you have some time to spend with us a little bit, or are you kind of got to run? I don't know where you're at.
I'm at. We just finished up an event. We had quite a few different people speak, and probably about 75 people here, and I do have a few other people I need to speak with before the evening's over, unfortunately. So I would have to get going, but I would be more than happy to be on the show and maybe talk about how the case ends up after tomorrow.
All right. Joshua, thank you for coming on the program. We'll explore this in further detail after these commercial messages. We'll be right back.
You're getting the full melt.
What's up with these things, Victor?
We decided to give ourselves stickers for each feature we release.
We read about 10,000 suggestions a week to create features that, as traders, we'd want to use.
10,000 suggestions. Who reads all of those?
He does.
For all the confidence you need, TD Ameritrade. You got this.
At book club, they were asking me what you're doing now, Janice.
Blogging. Your blog is just pictures of you in a mirror.
It's called a fashion blog, Todd. Well, I've been helping people save money with Progressive's discounts. Flo, can you get Janice a job?
You should have stuck to softball. I was so much better at softball than Janice did.
Where's your wife, Todd?
Vacation.
Discounts like homeowners, multi-policy. I got a discount on this ham.
I've got the meat sweats. It's good ham, Diane.
Paperless discounts. Give it a rest, Flo.
Yeah, Flo, give it a rest.
We ask people to tell us something that happened in their past and something that might happen in their future. The good things were put on yellow magnets and the bad ones on blue. The results show the past was a pretty even mix of good and bad, yet the future was almost all good things. Now that you've seen the results of this experiment, what does it mean to you?
We all want to think about positive stuff.
Realistically, there will be down times.
It's great to think optimistically, but let's plan for whatever the future might bring.
Prudential, bring your challenges.
If you're like us, your pets aren't just animals. They're members of your family. Pet Pain CBD hemp oil drops are great for aging as well as active dogs and cats. Some people are apprehensive about hemp treatments for pets. They ask us, what are you smoking? Absolutely nothing, and neither will your pet. Like other hemp-based products for humans, the allure is all of the benefits of cannabis without any of the high. The CBD oil has shown to rejuvenate the bones, joints, brain, stomach, eyes, and heart. And the drops contain absolutely no corn, wheat, soy, artificial colors and flavors, or preservatives. Pick some up today. Visit petpain.com or ask for Pet Pain at your local pet store. Petpain.com. CBD relief for your pet.
It's the Full Melt Radio Show. All right. So we have been talking to Joshua Covert, who's the attorney for Allen Witt. Allen was working at a dispensary. I wish I had some more time. I didn't know that he wasn't going to have a little bit more time to talk about some of these issues. I know that if I was in his situation, I would want to spend too much time between trial hours and preparation and all of this, talking to people ancillary about a case that is still yet at trial. He did happen to mention, and I thank him for it, that he would be happy to come back and kind of give us updates as to what's going on as the trial progresses. I would anticipate, in my estimation, and I think in most people's estimation, that this may take a day or two to progress. I don't know how many witnesses there are. I have so many other questions that I'd really like to ask Mr. Covert, and perhaps I don't know. It's a little late in the program to do it now, I suppose. But it wouldn't hurt to see if perhaps David Rudoy wouldn't want to come on if he's got the opportunity to discuss this. The idea about a Section 8 defense and the idea about how that's best maintained and who might need to maintain it. So I'm just going to text him really quickly while we're talking here. David, do you have the time? A short minute to come on the show. David runs his practice out of the Royal Oak area at rudoylaw.com. And I'm asking about Section 8 questions. Because, really, and it doesn't matter to this trial anymore. This issue has already been decided by this trial court. Because 2 of the 3 elements, I think he said, if I gathered out of that the actuality of it, at least he said that 1 element wasn't met, and that was the idea that that they were not engaged in the medical use of marijuana because they never discussed this issue about weight and dosage and how much you might need, what your condition is, because you were unable to describe what those factors were in your transaction. That you don't deserve a Section 8 defense at trial. And I suppose even beyond that, I would wonder, and this is just another side question. Most of these dispensaries have, video cameras for security purposes, taping things that are going on. At least, I don't know if it's taping it, but at least, and most security systems do record what's going on cameras, and you can select this depending on your security system, what you want recorded, what you don't, when you want recording, when you don't, how often it records, how fast it records. There's all kinds of variables. But my point is, if you're at one of these places and you're on security footage having this transaction and you're a confidential informant, you would think that much of what's going on there would be caught, you know what I mean, by the cameras. I suppose the cameras are really there to identify individuals, though, not necessarily so much as to the conversation that took place. It seems also that there's been some people that have thought about this since the Hartwick-Tuttle cases came back from the Supreme Court with guidance. And that's what establishes these 3 elements, I suppose. Is engaged in the medical use. What are they? I just got to look them up real quick because do I even have them on here? I think I do in photo form for quick reference. I know I have something on here. I think it's that. Yeah, here we go. So you got to have the bona fide doctor-patient relationship where the doctor has certified you as having a qualified, condition, and that you're likely to receive therapeutic or medical benefit from the use of cannabis. And then the second element is that the patient and caregiver were in possession of an amount together that weren't more than reasonably necessary to ensure the uninterrupted supply of marijuana to treat the patient. And then number 3, that the patient and or their designated caregiver was actually engaged in acquiring or growing the marijuana for the patient. Those are the elements. It seems to me, and I was incorrect in my assumption earlier because I didn't get a chance to hear the, this is not something that was broadcast. These kinds of trial things don't happen usually before a live audience outside of the courtroom. And I suppose there were people that could have played that hearing, because it was a Section 8 defense hearing that occurred this morning. They could have streamed it, I suppose, and there may have been people that did do that. I only saw some video recordings that were made from consumer cameras that weren't attached to any microphones. It was very difficult to hear and not necessarily extremely clear or complete in the statements that were made. So not having had that opportunity to be in the courtroom and listen to it, I made the assumption that what the judge likely did was decide that 2 of the 3 elements, because one of them wasn't met, another one also was not met. And I guess it doesn't matter anyways, because if you don't meet all 3, you don't get your defense. You've got to have all 3 legs. You can't just stand on 1 or 2. You got to have all 3. And so if one falls, it doesn't matter that it might also cause another one to fall because one's gone. So, but my assumption was that the doctor-patient relationship, which is most often attacked, that's probably the easiest to attack, the easiest to get a quick win on, was the leg that he didn't meet. It seems that that's the one that he said was met. The other 2 being that you were in the possession of an unreasonably, that wasn't more than unreasonably necessary to provide the medicine necessary for your condition, and that number 3, the patient and or their designated caregiver was actually engaged in acquiring or growing marijuana for the patient. Now, acquiring or growing, if you're in possession of the marijuana, as Mr. Covert was just talking about during the last break, during the last program segment, he's saying that as a person behind the counter, as a bud tender, that you are in possession effectively of everything that you have control over under that counter, and so is anybody else that has that control. They're also in possession. And if you're going to then distribute some of that to somebody else with a medical condition, that it's been suggested that you might want to have that conversation. Now, is that going to make the lines longer in dispensaries? Probably. It probably will. For those that employ or deploy that tactic as a defense mechanism, because that's what it would be. I mean, this is why they have listings on the back of any product you purchase in the store. The ingredients that are there listed for the defense of the company that made the product, not so much as an informational thing to you. They put it on there so that they're not going to get sued about what's in there. They put it on there so that they're not going to get sued about not meeting certain standards. I mean, this is why all that product labeling requirements are there, so that people have a reasonable understanding about what they're getting and how it got to be where you're purchasing it. And those arguments still happen. There's this argument about GMO foods and whether or not they should label GMO foods in a store. The food manufacturers don't want to label it that way because people tend not to buy it. And GMO foods are generally the higher profit margin for the food manufacturers. So they'd rather you not know and still buy it rather than tell you and have a lower sales margin. You see, this is the kind of thing going on in labeling and consumer marketing and this kind of, regulation. But it still belies me that the courts would want to determine that in order to present, and there's no place in the law for this to stand. I don't get where they get this from. There's no wording in the law as it was written in the Michigan Medical Marijuana Act passed in 2008 that says anything about dosage that says anything about timing of that dosage, that says anything about having to disclose your actual condition to your caregiver. None of that. I would assume that you might know as a caregiver what your medical patient's growing needs were, but you're only ascribed under the act, in my opinion, in my plain Joe reading of the language of the law. There's no duty ascribed to the caregiver to understand anything about the patient's medical situation, aside from the fact that they have a qualifying condition that's been certified by a medical doctor. That's it. As far as I'm concerned, the duty of a caregiver ends the moment he's been given what appears to be a valid medical marijuana registry card or valid paperwork certification from a doctor that says you're registered, that says that you have a qualifying condition and will likely receive benefit from cannabis. That's it. Your duty ends right there. Once you've obtained that information, you should, as a requested caregiver under the Section 8 laws, under the Section 8 defense part of the law, be allowed to act as a caregiver for the person seeking said cannabis for medical use. You don't have to be necessarily connected to the registry. The registry only gives you protection against arrest and prosecution. That's all the registry does. Having that card for yourself and your patients, if you're a caregiver, only gives you a protection against arrest and prosecution, assuming you've done everything right with Section 4 requirements. How much? 2.5 ounces per patient, no more than 12 plants. They got to be kept in a closed lock facility. All that goes to whether or not they can arrest or prosecute you. Assuming that you've got less than 12 plants per patient and that you've got less than 2.5 ounces of usable marijuana per patient as a caregiver, or as for yourself, and assuming that it's in a closed lock facility, you should have all the elements of not having to be charged if they discover your marijuana grow, because you meet all the elements for not being arrested or prosecuted. The question is, if they find an extra plant or a little more weight, they can arrest and prosecute you, and you still have this Section 8 defense under the Michigan Medical Marijuana Act law. You're supposed to be able to present that defense, an affirmative defense. Yes, I did it, but I have permission pretty much. I have an allowance, and I shouldn't be prosecuted for it. As a defense at trial, the triers of fact never get to hear these facts. We'll talk a little bit more about that in a moment.
You're getting the full melt.
Promotional consideration provided by NoSmell.com, pioneering the storage market for cannabis users. The NoSmell patented bag technology offers users 100% smell-proof detection from even the most sophisticated of noses. NoSmell.com, so nobody knows. When placing your order for a no-smell bag, make sure to use discount code FULLMELT and take 10% off the entire order. Learn more about no-smell technology at NoSmell.com.
Young students are our future. They're eager to learn, eager to succeed, eager to make the world a better place. And they want to make it to school safely. Share the road, take care when passing, and always leave 3 feet between you and people on bikes. Bikes are legal road vehicles. We're all drivers.
When you need legal help, you don't want to guess at who's standing next to you in court. And when it comes to a medical marijuana defense, it's even smarter to partner with a lawyer before you need one. Based in Royal Oak, David Rudoy has a proven history of not being afraid to take your case all the way to the Supreme Court and win. Find the law offices of Rudoy Law
at RudoyLaw.com.
RudoyLaw.com is a quick reference on your rights concerning Michigan medical marijuana
and up-to-date news.
That's RUDOI Law.com. Call 248-935-9074 now and talk about your legal needs, because at RudoyLaw.com, we don't just stand up for you, we stand up with you.
If you're like us, your pets aren't just animals. They're members of your family. Pet Pain CBD hemp oil drops are great for aging as well as active dogs and cats. Some people are apprehensive about hemp treatments for pets. They ask us, what are you smoking? Absolutely nothing, and neither will your pet. Like other hemp-based products for humans, the allure is all of the benefits of cannabis without any of the high. The CBD oil has shown to rejuvenate the bones, joints, brain, stomach, eyes, and heart. And the drops contain absolutely no corn, wheat, soy, artificial colors and flavors, or preservatives. Pick some up today. Visit petpain.com or ask for Pet Pain at your local pet store. Petpain.com. CBD relief for your pet.
Hey, it's Steve Green for the Sweet Leaf in Flint, because now getting safe access to medical cannabis patients in Flint, Michigan is never more welcoming. Presenting the Sweet Leaf, a brand new patient experience, bringing 12 carefully selected caregivers housed in 9 separate offices to distinctly assist you with their knowledge and reputation for excellent patient care. Classes and training coming soon in the large community room. Check it out in person, 400 South Door Highway, or call 810-259-2571. The Sweet Leaf Center in Flint, 810-259-2571. It's the Full Melt Radio Show. All right, so I think I might have gotten David Rudoy on the phone. Hang on a second. Hey, Dave, stand by a second here. It's Steve Green. All right. So I think we have you connected up now. Are you there? Can you hear me?
I am here, Steve.
Terrific. It's Attorney David Rudoy. And we've been talking about, you've seen, I'm sure you've heard tale about what's going on up there in Gaylord, yes?
I have, but I've been stuck in court all day, so I just know that the Section 8 was denied. I haven't had the chance to talk with Josh.
Yeah, we just had
Covert about exactly what happened.
Yeah, we did have just Josh on the air for a few minutes describing what happened with the Section 8 defense, and it seems like they met the element of doctor-patient relationship, the bona fide doctor-patient relationship, but failed the element and having the certification, but failed the elements of not having more than reasonably expected.
Reasonably not to.
Right,
Yep.
and the last one of actually being engaged in the medical use of marijuana.
I had a feeling that prong 3 was going to be the major problem, to be honest with you.
Well,
based on the facts of the case.
Does it seem that's the I'm just trying to figure out myself, because I always assumed, because it's the most picked on, is the bona fide doctor-patient relationship issue, but probably it's just because it's the easiest target to win on, I would think. But it may be harder to beat to meet some of the other burdens of proof in these other legs for Section 8 defense to stand. Does it vary a lot depending on the case, or is it pretty much in your head something that is firm in your head about which of those legs is hardest to meet?
A is hardest. Bona fide doctor-patient relationship. 8A1, I'm sorry, is the hardest. The bona fide physician-patient relationship and the statement being made in that. And it's because it's very easy for them to attack. Okay, and we've raised the standards for what a bona fide physician-patient relationship requires. Back in the old days, pre-medical marijuana, like for malpractice purposes, you can have a bona fide physician-patient relationship with a doctor that you've never met, that the nurse called while the doctor was on call.
Oh, wait a minute.
Enough to sue that doctor for malpractice.
I didn't know that there were different standards for bona fide doctor-patient relationship. That's an interesting facet you've just pointed us to.
Yeah, I mean, it's crazy. And then the legislature comes in. First, the courts were trying to build it up to be so high. And then the legislature came in and just made up some bullshit, like that they have to ask you to contact your primary care physician and everything else. I mean, these are just, it doesn't exist in any other realm of the law. But the legislature did it. We got to follow it. But the good thing about that is now we know, as medical marijuana attorneys, and somebody as good as Josh Covert knows, I mean, they've laid out exactly what you have to present evidence to. The big problem for Josh's case, and the thing, he was actually on Planet Green Trees the other night, I was asking him about this, is when his position, when you sell to an undercover cop, right, prong 3 is that it has to be used for medical purposes, intended for the patient's medical purposes. So how do you prove that without the patient getting on the stand and saying, this was intended for my medical purposes?
Well, and
so it's great. It's easy to prove when you have a patient come in and testify to that. But when it's an undercover officer or somebody, even a CI,
that's
that was never
uncooperative,
intending to use it for medical purposes, then you're kind of, and it's a big problem with the law, you're screwed in that situation, which is why I'm appealing the Carruthers case. Because I think that's entrapment in the sense that they are depriving you of a defense by their actions.
Well, it's impossible to meet that prong under that circumstance, is what your argument would be.
That's the problem.
It's impossible to meet the burden of proof necessary to sustain a Section 8 defense ruling in your favor if you've got to indeed prove that the medical use was that the patient was seeking medical use. In this instance, the patient was seeking to try and trick you because they lied about it. What if the instance of how do you meet that burden? It seems ridiculous.
Well, that's the big problem for these sort of cases, and that's why we are appealing the Carruthers case up to now. Not the use of not the Carruthers case about edibles, okay, but the other Carruthers case that's about entrapment, and that's why we're appealing that up to the Supreme Court of Michigan. It's because it basically. All the cops have to do to defeat that element is to send in a CI who is not intending to use it for medical purposes. And it becomes, now, there are ways to do it, okay? But it becomes, with documentation is the best way, because you have to at least create a question of fact to get it to the jury. But if the documentation isn't there, it's very difficult to prove that prong 3. And that, I had a feeling, was going to be a big problem for the case up in Gaylord.
Right.
You can't. What are you going to? How can you present evidence to that in those circumstances? And it's just very difficult. And I know Josh had some hope to argue, some language in Hartwick and Tuttle, but judges don't buy new arguments.
Right.
I think Josh had a good plan to deal with it, but the problem is basically, the rule of thumb is if a judge can deny your Section 8, a judge will deny your Section 8.
Which brings me to my next two questions. The first one is, are you aware in your knowledge base of any defense that has been granted Section 8 allowance to present their medical marijuana defense at trial in Michigan?
Yes, I am.
So is it more than one or just one?
Well, I can tell you for sure Michael Comorn has had multiple. I have had 2 in my career that have been the Section 8 defense going to trial. And most of mine have been slam dunks where the judge just dismisses the case. But I can tell you for a fact Michael Comorn has had many.
That's interesting. It's a question of
many.
Question I've never asked before.
Where it works.
It's a question I've never had the opportunity to ask before, so I'm glad that you opened that door for me.
Yeah.
There's another issue you were mentioning about. See, I've lost the second question. It's with regards to the medical marijuana defense with regards to the person that's at the dispensary, the bud tender. So some people, and I think you may have been involved with this or may not, I don't know, but I think there's been a group of attorneys, many of them you've mentioned already, that have decided to maybe kind of bump heads together and figure out a way to provide some documentation planning for this kind of a question. So I saw today there was a post, and it's on my webpage, some paperwork that I believe somebody put together so that if you're a caregiver or if you're a bud tender or if you're working at one of these dispensaries, that you can actually fill this questionnaire out with your patient, and then you've got some of the documentation you're talking about in order to meet some of these defense elements necessary in court. Would you say that that's a good plan, that that's a good way to go?
Well, to be honest with you, I don't think that there's any good way to go being a bud tender in a dispensary currently, because there's just the judges are looking to screw you. If you're in a favorable territory, but I would not, recommend legally doing it, for various reasons.
Right.
But if you're going to do it, then yes, you need to be preparing to have a Section 8, because right now the courts are not accepting that it could ever be Section 4 covered, which I disagree with.
Right.
McQueen was a case about patient to patient, not caregiver to patient, which is a very important thing to note. But courts courts are using McQueen to say no Section 4 for dispensaries ever.
David,
so, I mean, stuck with Section 8, build the elements.
We're out of time tonight, Dave. David, we're out of time. We're going to hit the end of the show. We'll bring you back on maybe tomorrow or another day to talk about this. Thanks.
The Full Melt Show is a production of TFM Media.